I told him that if we went to trial, there was a 99% chance that we would lose. And you know what he said? I don't care. I want you to go to trial. I want you to do everything possible because I want to take that chance for that 1% that we go ahead and win this case. You want to know what this is all about? And whether we did, in fact, go to trial? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This was a case I handled many years ago, and now it was a medical malpractice case. I had two medical experts, two qualified medical experts. They were both board certified in their field, excellent physicians, who basically told me, yes, we had a case, but it's not as good as the defense's case, meaning they felt the defense had a much stronger argument on liability to establish that the defense did absolutely nothing wrong than we did going forward. Now, something interesting you should know. During the course of the lawsuit, when we notified the court that we were done with the discovery phase of the lawsuit, interestingly, the defense has an opportunity at that point to go ahead and ask the court to throw your case out before ever getting to trial. That's known as making a motion, a written formal motion to the court for summary judgment. In this particular case, the defense did not do that. And the reason they did not do that is because there were questions of fact, meaning that there were disputes, factual disputes that were critical to the key issues in the case that prevented the defense from going ahead and trying to get out of this case before it ever got to trial. So now I knew that in all likelihood, because the defense told me that there was no way they were ever going to settle this case voluntarily. And I knew that no matter what we did to come back to them and say, hey, listen, I think you should settle this case. I knew from speaking to the attorney that the defense had no interest whatsoever. They thought this was a defensible case and that they were not going to offer a single dime to try and negotiate or settle. So having said that, now we were getting prepared for trial. I have now met with my experts. I have now sent out subpoenas to obtain medical records so they could appear in court at the appropriate time when we go ahead and try this case. I now subpoenaed various witnesses to come into court so that now I could have their testimony and the jury could hear their testimony. I met with my clients multiple times to prepare them for what was going to occur at trial in terms of direct examination, me questioning my clients at trial, as well as cross-examination, as well as what they could expect to see and hear during the course of the lawsuit, during the course of the trial. And as we are discussing this, I have a very honest and open conversation with my clients because they want to know what is the likelihood that we are going to win this case. They want to know what is the chance that we could lose this case. They want to know if there's still a chance that the defense would try and settle this case before going to trial or even during trial. So I'm having a very open and honest conversation with them. And I had just come back from talking with both of my experts. And both of my experts were not very keen, not keen at all, about us coming out on top of this case. In fact, neither one of them felt that we had the ability to proceed forward. Neither one, which now puts me and my client in a severe pickle. It puts me in a very bad bind. Why? Because by this point I had already notified my adversary that we had various medical experts who I had identified by their credentials, not by their name, but with some simple online digging, it's pretty easy to find out exactly who it is that we are bringing in as an expert. And we do the same thing when the defense notifies us who they plan on bringing in as well. Both of my experts are now telling me, listen, you can't prove your case. You see, in these types of civil lawsuits in New York, we are required to show that we are slightly more likely right than wrong than what we are claiming is true. And if we are unable to do that during trial, once we stop, once we rest, meaning that we have no more witnesses and no more evidence and testimony to put on, the defense will jump up out of their seat as if an ejection button was pressed and now demand that our case be thrown out. Why? Because they will claim that we have failed to establish what's known as a prima facie case, meaning that we have failed to establish the basic elements necessary to go ahead and establish that we are entitled to a verdict in our favor. It doesn't mean that we are. It simply means that we overcome this hurdle and now we proceed to the defense's case and then ultimately to the jury. But if we cannot even make out a case because our experts are incapable of coming to the conclusion that we are slightly more likely right than wrong, then guess what? We have a major problem. Now I can no longer use these particular experts to establish liability, to show that these doctors were careless and caused significant harm and injury. So that means I will now have to rush extremely fast. Time urgency is there to try and obtain other medical experts to review all the records, and now to give me a favorable opinion so that I can then notify the defense that I've hired new experts and then be able to bring them into court at the appropriate time. And this is very, very difficult and very challenging to do under short notice. Number one, to be able to find an expert who's willing to drop everything else that they're doing and then go ahead and review all the records and then hope and pray that they determine that we do in fact have a valid case. Because if it turns out that they now review the case with an extreme time urgency and they come to the conclusion that no, we don't have a basis for a case, well, now we're not only out of time, but we're out of luck. And that is a major, major problem. But let's get back to the question I raised in the title of this video. My client asked me, what are the chances that we are going to win this case? I said, at best, you have maybe a 1% chance of winning this case, assuming I can find another medical expert to confirm our case. Now they said, why? I said, because the defense has a much stronger case than we do. The facts are on their side. The medicine is on their side. And the only way that you'd be able to win this case is if the jury disregarded the facts, if they disregarded the evidence, if they disregarded the medical expert testimony. That is the only possible way I could see you winning this case. And you know what he said? He said, I don't care. I still want to go forward. And I told him the reality. I said, we can't go forward without a medical expert who is able to testify on your behalf. I am not permitted to go ahead and start this trial. Ethically, I can't do it. We are required to have a medical expert. If we go ahead and put on testimony, and I put you on the witness stand, and I put other witnesses on the witness stand, but I don't have a medical expert to support our claim, guess what? The moment I say the plaintiff rests, the defense is going to jump up out of their seat, ask the judge to throw this case out. Why? Because they will say that in these medical malpractice cases, we are required to have a medical expert confirm that we do in fact have a valid case, that there was carelessness and that the carelessness was a cause of your injury, and that your injuries are significant and permanent. If we do not bring in a qualified medical expert to establish all those things, guess what? The judge would be fully within his right to go ahead and throw out your case, to dismiss your case, and that's the end of it. So now my client was insistent. He said, no, I don't care. You're going to go forward. And I said, if you insist on doing that, I have no choice but to ask the judge to relieve me of my duties as your attorney. And he says, no, you can't do that. You've been on this case for years. I said, it's true. I have been on this case for years. And I have spent tremendous amounts of time, my energy, my resources, and money that I have invested in you, in your case, and hired various medical experts and have incurred significant expenses on your particular case with the hope and with the expectation that we would be successful. If we are not successful, then none of that money gets reimbursed to me, and now there will be no attorney's fee because we are going to lose this case. The case is going to be dismissed. So knowing that at the very beginning, where we don't have qualified medical experts to confirm that you have a valid case and testify to that at trial, I have no choice but to withdraw as your attorney. Judge will then give you a certain amount of time to go ahead and try and find another attorney to take over this case and to try your case. So why do I share this quick information with you? I share it with you because that's exactly what I had to do. I actually had to withdraw as the attorney in this case, and it was no longer possible to represent this client because my client was being totally 100% unrealistic in spite of exactly what my experts had told me. He didn't want to hear it. He didn't believe it. He felt he was right, and he felt that we should still go forward. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.